we were trying to take Paul's place for a few minutes because the chairman is at another hearing. So I'd like to open the hearing on petition 33. Which is Representative John West brought to us, and we'd like to start off with John speaking. Representative?
Thank you. I'm Representative John Burt, and I'm bringing petition 33 forward for redress of grievance on behalf of Nick Haas of Cookson. I guess at this time I would just turn over and let Nick, if you don't mind, carry on from where we basically left off, or at some point, if that's okay. All right, thank you.
Good morning.
Let me interrupt you because I run a little different than Paul. If any board member has a question, I'd like to let them ask the question at the time that we're speaking. So I may interrupt you with another board member question. Do you mind?
No.
We'll do it anyhow.
That's fine. That's fine. I do believe that I thought that the focus of today's hearing was going to be for the public, for the rebuttal. That's what I had read.
Response hearing.
Yeah, the response hearing. It was supposed to be for today, so I was prepared for that. However, I'm prepared to go forward and continue our last hearing if that's the desire of the committee.
It's supposed to be the response hearing.
Right now, we read this. This is continuation of the hearing.
Well, I do want to address something from the last hearing that we had, and I didn't comment at the time on it. The question came from Representative Corrigan in one of our last hearings, in the last hearing, I believe. He had made the suggestion that at the time, my ex-wife it wasn't mandatory that she report the house that her father had purchased for her. That's actually inaccurate because on a financial affidavit, you are supposed to list gifts as part of your assets, and $264,000 house certainly would constitute as a gift. Also, for the record, and I want to stay on that one particular point, this house was purchased by her father 5 days prior to our actual divorce. So that would be a house that was purchased during the time we were also married. So I just want to make that clear for Representative Corrigan.
I have a question now.
Yes.
Was that house deeded to her?
No, sir. It was a purchase by her father. She and the children reside there today.
So basically, yes. But basically, the house was her father's, not hers.
It could be assumed that it is his since he purchased it, yes. But he does not reside in the house. He resides in Needham, Massachusetts.
Is the deed titled in her name or in her father's name?
I do believe it would be her father because he is listed. Right. The point here is that it wasn't listed on the financial affidavit, regardless. That's what I'm suggesting. If that's a gift, if one is residing there, that could be assumed that it is a gift. It should be listed on the financials. If there's rent being paid, however it's worked out, it was not listed on any financial affidavit. And again, for the record, it was 5 days prior to my divorce it was purchased.
And Mr. Chairman,
Yes.
may I add a little bit?
You can certainly ask.
Thank you. And if I understand right, with the child support guidelines, there should be at least a value. If the house is not in her name, the value should be listed as rent paid. Even though there was no rent paid, there should be a value. It's like if somebody gives you a car. If I understand the correct law of the child support guidelines, that you would have to list at least the value of that, because you're not paying for it, but there is a value.
I just wanted to clear that up. That was brought up by Representative Horgan last year.
I still have a little problem with what I didn't clear that up with the representative, that even though not the value of the house has to be in there, but the value of the rent if she was living there should be in the statement.
That's my interpretation.
I think
Like a negative liability, because it's rent she doesn't have.
Yes, so it should be considered, part of income, an asset.
Are there any more questions? Anybody else like to speak?
From the last hearing, we were still, with the summary that I provided to the committee, I know that we were going through that, and we had finished page 1, really, of that summary. As you go through that, I didn't know if the committee wanted specific examples. I've got every offer of proof here on the table for you. And I do know that I've been submitting things to the committee, via email. Hopefully you've been receiving them and able to see. One of the committee members asked for a copy of, when I was incarcerated, the bail conditions in the letter. That was sent out to the committee. Hopefully you all received that. You could read that.
Any hard copy of any documents would be appreciated. Helps us.
Sure.
Mr. Chairman? Are any of these people here about this matter?
I asked if anybody else wants to speak on it.
Oh, I didn't hear you say that. I apologize. I didn't hear you.
Yeah. I'm ready. If we're to continue this morning, I'm ready to discuss kind of the part 2 of my petition. I think we talked about the beginning, part 1 of my petition, which is the marital master's order that was incorrect from the start, what had happened, and then that led up to the incarceration. That's kind of the marital masters and Manchester Family Division's incorrect orders that led to that. There's also a piece in this which is the guardian ad litem, and I don't know if we've really addressed a lot of those concerns. It's part of the petition. Yes, thank you. I presented to the guardian ad litem board on the 16th of March, and they have seen part 2 of this petition, which is the violation of the standards of the best interest of the child standards that we have in New Hampshire.
What year, 16th March of?
This year, just this past March 16th.
Okay, thank you.
The policy of the state of New Hampshire is to encourage co-parenting. RSA 461, created by this legislative body, says that children do best when both parents have a stable and meaningful involvement in their lives. And it's incumbent on us to support frequent and continuing contact between the child or the children and both parents. Additionally, under that, paragraph A6 is the determination of best interest. So the statute goes on to define what we see as the best interest. And those are the ability and disposition of each parent to foster a positive relationship and frequent contact with the other parent, both physical, written, and telephone. The support of each parent for the child's or children's contact with the other parent by allowing it and promoting it. Any evidence of abuse as defined by RSA 173B1, 1 or RSA 169C32. And in determining parental rights and responsibilities under paragraph 3, including residential responsibility of the children, the court should not apply a preference for one parent over the other because of the sex of the child, the sex of the parent, or the financial resources of the parent. From the time of November 20th, 2006, when she was appointed, the guardian ad litem in my case, Suzanne Decker, was assigned by the court, and she completely failed to perform her sworn duties in every way possible. She promoted a bias and a prejudice against me with the court using the authority that was given to her. I can prove to the committee beyond a reasonable doubt that GAL Suzanne Decker simply sided with my ex-wife at the time. She plotted to alienate me from both of my children. And unfortunately, this GAL put her own financial means before the welfare of my two daughters. She ignored eyewitnesses that came forward to testify to her, which by law she is supposed to speak with witnesses. They were given to her up front by counsel, and they were given to her ongoing. Some of them even reached out to speak to her directly, and she ignored their phone calls and emails. She ignored contentious exchanges that my children and I had to endure while we were visiting with one another, that she was kept up to date completely on. And she ignored the witnesses that also came forward to testify. They had seen those contentious exchanges, and they witnessed myself being verbally and emotionally abused in front of the kids. What this all did was, this ultimately forced me to act as a loving parent in the best interest of my two daughters, with a protective measure at the time that greatly affected our relationship too as well. I think the committee already knows at that time, on September 26th of 2009, that Saturday, I said I'm no longer going to have my children have to deal with this. It's an impossible situation. If this GAL is going to perjure the court, if she's going to lie, if she's going to ignore all of the facts coming forward, and my children, every time we visit, they're getting worse and worse, and they're being forced to have to witness this abuse. It's not good for them. That's not in their best interest. So I told my attorney at the time, I told the GAL at the time, until you do something, I'm suspending my parenting time because it's putting my children in a very, very difficult situation. They're crying, they're screaming, they're seeing problems between their parents that they should not see, and all the while, and I can show your committee, I had been trying to tell the GAL she wasn't allowing the co-parenting to take place. And this was for well over a year and a half. I mean, it was just constantly contentious.
I've got a question.
Sure.
You keep using the word a lot, ignore.
Yes.
When you use that word, are you talking about when you present this to her, or when it's presented at some type of court case or a hearing?
Thank you.
Because there's a big difference to me.
Okay. When I present this to her in email exchanges, I was telling her every visitation I had with my children. She was ignoring that. I have letters from folks who came forward saying, I've been trying to reach Ms. Decker. She's ignoring my telephone calls. When I filed things with the court, and especially in the later months, which you can see in this case, she was ignoring those motions. She was ignoring me asking, could you please help out in this matter? What can I do to co-parent my children? She was basically, when I say ignore, I mean she was choosing not to respond. When I asked Ms. Decker why she was ignoring the facts, why she was ignoring witnesses, why she was ignoring police reports, why she was ignoring evidence, and why she insisted that no alienation was taking place whatsoever, it wasn't occurring, she angrily asked me, why have you not paid me? Which also leads me to believe that GAL Suzanne Decker could be swayed one way or another in her judicial capacities based on financial incentives. GAL Suzanne Decker conspired with my ex-wife's attorney, and she attempted to set me up by ordering that only I take a parenting assessment and a psychological evaluation. The psychological evaluation and parenting assessment deemed me a fit parent. It also suggested, in the psychologist's own words, that he thought it was quite possible that I was also being alienated from my children. He concurred with another counselor that I'd been seeing at the time for about 3 years that also was trying to tell the GAL, this man is being alienated from his 2 daughters. So we have a big problem. We've got a person assigned by the court that is choosing not to do anything, take no action, and in fact put it on me and suggest that it's all me just fabricating something, which is just sickening. You can't ignore police reports, which is a wonderful thing. They're on the record. I've got multiple police reports. I had to have them involved in my matters because of harassing phone calls I was receiving. I had to have them involved because of contentious exchanges my children had to witness, because when I would pick them up, I would be battered, verbally in front of them. The list goes on, and I think in the summary I've provided to you, you'll see the multiple cases. They're all docketed there. You can research them. In fact, if you go back to 2005, you'll see the divorce proceedings, and that's why I listed them. In 2005, they actually began back then when I had to file an ex parte motion because there were threats to my children that she was going to potentially harm them and herself. And that was in August of 2005. So when I bring up RSA 461A and the statutes of the state of New Hampshire under that particular statute, it's clear there was no fostering a positive relationship and frequent contact between my children. I still don't get to speak with my children. And I still, to this day, don't understand why that is. There's no court order prohibiting it. Other than I'm being told by my ex-wife, you're not allowed to have calls with them. And she also states that the GAL specifically told her I'm not allowed to speak with them. She says that the GAL and the therapist for my oldest daughter agree together that they shouldn't have telephone contact at this time with me because of what happened in September 26, 2009. That's ludicrous. It's damaging these two children immeasurably as we sit here. Imagine being a 9.5, well, almost 10-year-old child and an 8-year-old child believing that your father just kind of stopped seeing you and you don't know why. There was no fostering of the positive relationship and contact with my kids. To this day, there still isn't. The therapist was hand-selected by my ex-wife in the GAL. There's another very big problem that we have. I explained to them I don't agree with this selection. I was at that time being told, and I'll show your honorable committee. I've got it all here for evidence for you. I was told at that time you're holding up proceedings if you're not going to agree to a person we're going to select. Well, the reason I didn't agree to this therapist that was assigned was because I went to meet with her. And I'm going to read you the email that I provided at that time when I met with her. February 18th, 2009. Suzanne Decker. For the record, here is how I was informed of the counselor assigned to my daughter. Yesterday morning at 8:15 on the day of court. The only other information I have concerning the therapist is her online printout that you handed me right before we went into the courtroom that day. So I went into court one day, and the next thing you know, there's a therapist assigned to my daughter. I received an email back from Suzanne Decker. Hi, Nick. That's what I expected, my ex-wife's name, to do. What were you expecting? I guess I'm not sure what else she should have done. I think the ball is now in your court. if you need something more, I guess you should ask your ex-wife or the counselor herself. And so rather than hold things up, I did. I went to visit with the counselor. And so I wrote on the 12th of March 2009 to my attorney at that time and to Ms. Decker, the GAL. I wrote, Suzanne, thank you for calling me just before 10 a.m. this morning. Thank you for also having a discussion with me at 10:24 this morning for a few moments. Brian, who was my attorney at the time, thank you for discussing my concerns over the phone as well. Please understand that I have extreme reservations about accepting Mo Shine as my daughter's counselor. Those reservations from my first meeting with her are as follows. 1, her office is right down the road from Attorney McCool's office, the attorney for my ex-spouse. She happens to know Attorney McCool very well. He refers clients to her, and she refers clients to him. To quote Ms. Shine, he gets the legal stuff and he throws me the emotional baggage. I was very taken back from the comment emotional baggage. I do not want to ever hear anyone refer to my daughter as emotional baggage, or be heartless enough to describe a very difficult family situation as lightly as this counselor did. That bothers me. She also described the Attorney McCool's demeanor, and she jokingly said, he can be a bit abrasive to people sometimes. She was joking with me during the meeting. I didn't find it funny because unfortunately for about 2 years I was a victim of that abrasiveness, and I didn't think it was a very funny comment. She also admitted through that comment that she knew him fairly well enough to make a comment such as that. So here's a therapist being assigned to my child that happens to know my ex's attorney personally and refer business back and forth to one another. Does that sound like someone that could potentially be an unbiased party? I don't know how that's possible. So she also was looking at her watch. She was very busy during the appointment. She gave me exactly an hour. I had to, I read her as not really wanting me to take part in the first meeting at all whatsoever, which I didn't really have a good feeling about this being my daughter's therapist. I was told that I was holding up the process, is what I was told.
Could I ask you a question? You were represented by a counselor yourself at this time?
Yes, I was. Very, very limited because I was already about $117,000 in total debt over all the matters. And, yeah.
Had he or she had any input into the selection of the therapist?
He did not. No.
So how did the appointment come about then?
At that time, like his capacity was very limited. He would make a simple phone call, and pretty much he told me that, just go along with what the GAL is doing because, she's got to do her job. I had been trying to tell him clearly she's not doing her job, and I need someone to do something.
Well, the therapist isn't court appointed then, if that's.
We'll get to be a conversation here.
I'm giving into the fact there's so few of us, Mr. Chairman.
I don't mind. It seems to get to be a two-way conversation. I'd like to have it be directed to the committee. His answers more than your questions.
Yeah, okay, I'm asking for a follow-up. I apologize, Mr. Chair. So the therapist is not someone who's appointed by the court, but it's agreed upon by counsel, supposedly? Is that how it's supposed to work?
It's supposed to be agreed upon by the parties with the guardian. That's with my understanding.
Thank you. Thank you, Mr. Chairman.
I explained to them that I didn't wish to hold up any progress in getting my daughter into counseling. Rather, I wanted her to have the best available help possible and have a very neutral party. I thought that was... And at that time, I suggested Dr. Benjamin Garber, who's in Merrimack. He's a well-known therapist, and he's written a book called Keeping Kids Out of the Middle. He does a very good job about family conflicts, and I just suggested him. Instantly, I got a negative to that. I was told the response to it was Suzanne wrote to myself, to my ex-spouse, and Brian at the time, and said, I don't see a problem with motion. I think the court authorized me to make this decision. So I am telling my ex-wife's name to please make an appointment for her with Ms. Shine. We don't know whether or not my daughter would even like her. Time will tell. So I'm just being, rolled over. I felt completely one-sided and didn't have an opportunity to address it. I would think that we would have somebody who's in a little bit more professional capacity. So.
Mr. Chair, thank you. So do you believe that it was after the psychological evaluation with your daughter that it was determined that she should cut off relationships with you?
No. The psychological evaluation was far after this was occurring. The psychological evaluation was not used to cut off contact with my children either. And they didn't base stopping my communication on the psychological evaluation.
However, a follow-up? Thank you. So what I'm asking is, your daughter was suggested for evaluate and going for psychotherapy with this moonshine?
Yes.
And do you know if anything came out of that, or how long is she still?
She's still in counseling with her today. And when I do try and talk with Ms. Shine, I am told it's really a court matter. You need to go to the GAO. I've called Ms. Shine. I called Ms. Shine recently when I learned that she was also arrested for a theft charge down in Massachusetts somewhere, and I picked up the phone and called her regarding that. And there is no current, that's right, and there is no current GAL in the case right now because she was let go.
With all this going on, I still don't understand where the connection is that you cannot see your children. I mean, that's what I want to know. Why has the court told them?
That's a good question.
Allow me for just one moment to pull something for you.
I think, Nick's going to pull out paper, but the decision is really made among the ex-wife and the GAL that was appointed, and I think that's where the decision came.
Weekly phone calls. January 19th, 2010. Here's an example of to address what you addressed. This is typical. This is more than once. This is more than 10. This is more than 15 times. I'm just giving you one example. Okay. January 19th, 2010, 9:10 a.m. Good morning, my ex-wife. I would like to work with you to set a time every week for me to speak with my daughters. I don't know what is good for your schedule. Could you please tell me what days and times of the week that would be good to have a call with them? Thank you. Nick, this request has been discussed with Attorney Decker and Mo Shine. It is the feeling of both that it is inappropriate at this time, and your request will be considered once you have completed the evaluation. This particular time was around the time when then Ms. Decker had asked me to take a psychological evaluation. Okay, February 3rd. It has been over 24 hours since I have completed the requested evaluation with Dr. Edward Jacobs. We finished it yesterday morning. I would like to schedule the time once a week to call the girls, please. What day of the week and time works best? Thank you, Nick. Nick, this has to be discussed with Mo Shine and Attorney Decker. I was not aware it was completed. and I'm guessing that they will want to discuss this request once the results are received. GAL, Suzanne Decker at that time, Mo Shine were all copied on this. Neither of them took any action whatsoever. February 12th. It has been over a week and a half, and now this is my third request to speak with my daughters on a regular weekly basis on the phone. Please let me know what is best for your schedule. What day of the week and time? Thank you. Nick. Instead of getting nasty with me, you need to contact Attorney Decker. Thank you. Okay, so I contacted Attorney Decker. I've been requesting regular phone calls with the girls. This is my third request. I do not believe there is any court order prohibiting me from having contact with my children. On what grounds am I being denied phone calls with my children? I would also like to know why I haven't heard from anyone on this other than my ex-wife, who appears to believe I am being nasty, when in fact I have done nothing but politely ask to speak with the girls on a regular basis. Thank you. Over 3 days later, I received an email from the GAL. Nick, my recommendation is that there be no telephone calls until your evaluation has been reviewed by myself and Mo Shine, which, by the way, I think that it's a conflict of interest for Mo Shine to review my evaluation, but I have no problem in showing it to the world, committee members. I'm very happy to say it himself. I'm a very fit, loving parent. Frankly, Nick, you are the one who voluntarily ceased contact with the girls over 3 months ago. Picking up the phone now is going to upset them. With all due respect, I think you need to see this from the girls' perspective. Again, my recommendation is to wait. Suzanne. She's perjuring the court in this because she knows exactly why, because I do believe I provided you the copy of the letter. And I did that on purpose. The reason that there's many files that are very thick is because everything the GAL did, I documented. Because I knew I could not trust her. I could tell from the beginning, because I worked in sales for 13 years, I do know that you want to document many, many, many things. I documented every contact I had with the GAL. And if you read it, you'll see that I have been asking and asking and asking and asking and asking to have co-parenting for my daughter's benefit. I was only seeing them one Wednesday night a week from 5 to 7, which is extremely difficult to do as a parent when you get 2 hours with your kids in the town they reside that you have to travel to, take them for some dinner, which takes 15 minutes both ways on both drives, so you lose a half an hour. It's difficult to get a lot of things in an hour and a half. I was asking for more time with them, and I was being denied, which is directly against RSA 461A. And we've got a GAL assigned who did absolutely nothing in this case to prevent this from going on, which it was her absolutely sworn duty to do so.
Thank you, Mr. Chair. Just getting back to the therapist that was seeing your daughter with the GAL or the court, whoever appointed. Was there anything in her final report that she showed any reason that your daughter shouldn't have contact with her?
In the therapist report, none that I'm aware of, no. I've never seen anything.
You did receive a copy of the therapist report as far as your daughter is concerned?
No, Representative Hardwick, there is no report from the therapist. This therapist wasn't assigned by the court. This therapist was just decided on by the GAL and my ex-spouse for my daughter to go there. The court never took any action in that. They never assigned this therapist. I have filed multiple motions to revisit the parenting plan, only to be denied. I have filed multiple motions to reconnect with my children, only to be denied. And I filed them even at the Supreme Court level. I filed over 4 motions, and those are in the packet. Okay, you can see.
Were these denials issued after there had been a hearing in which you've been able to
No,
speak?
sir. There
So
was
you
no
filed a
hearing.
motion,
No, I even filed. Oh, I'm sorry.
No, follow. You filed a motion and without any hearing, you just get back something saying denied?
Many times I got that back the very day of court, when I even filed it. When I was getting back denials, I started filing ex parte motions so that it could be heard right there on the spot, and I would just get a simple chicken scratch note on it that said denied. That very day.
We all did.
Privilege right now today, you have a parenting plan.
Yes, sir.
Is that parenting plan being followed?
No, it is not.
And we cannot get the court to enforce it. Or Mr. Haas cannot.
Mr. Haas, thank you, Mr. Chair. Who is the judge not presiding, or are there different judges once you go through the court?
No, we have had this same judge since Ed Tenney. He stepped down. He recused himself.
He recused himself, but he was, I'm sorry, follow up? So he has been the regular judge?
Tenney was the regular judge for...
Tenney?
Yes. Marital Master Lemire was before Tenney. And now in Manchester Family, I have Judge Emery.
E-M-O-R-Y.
E-M-E-R-Y.
And he's, I'm sorry, follow up? So is he the most recent that has denied your request?
Yes, yeah. Most recently, he has been denying my request for RSA 311, which was the right to be represented. I filed a motion with the court to be represented because I cannot afford a counsel, going back to... it's difficult to retain a counsel. I mean, they're very expensive, and especially in a case like this, a point of...
Just a point, if anybody wishes to speak, I don't mind hearing directly from the local.
Sorry.
Yeah.
Thank you.
My wife was reminding me that that Judge Emery was signing orders going back to 2009, mid 2009. So even with Lemire, and I believe some of Lemire's orders, yeah, were signed by Emery.
Mr. Chairman, if I may, it's easy to, if you have a custodial parent, it's easy to annihilate and not allow the children to see that. The other parent, and I'm trying to think how to say it, because then you'd have to go back to court to enforce what's there. And that is the case here, is that there is a court order saying that Mr. Haas has the right to see these children. But then you have to go back in front of the court and say, look, this is what's going on. I'm not allowed to see my children. And if you can't get the judge to go along with it, what do you do other than break the law and go down and see your kids? And then they'll be, then she'll have the cops there. Because, I'll be real brief on this. I want to say it was August of 1985. My ex-wife and I were divorced. It might have been 86 because our divorce wasn't until 85, so it was a long time ago. I brought the kids back one time, and this is the case that I'm seeing here. This is one of the reasons I took this case on. My ex-wife then, we didn't have family court. My ex-wife said, if you don't behave and if you don't do this and this and this, jump through these hoops, I can't remember even what the argument was over. She said, you won't see your kids. And I basically told her to screw off, and I got in the car and I drove home. Well, that Monday, because that was on a Sunday, that Monday I called my attorney. Well, my attorney called Judge Mahady, which was the judge in Superior Court where family matters used to be held. And he sent a letter down saying that if you say that again, we will look at you as being an unfit parent, because at the time, Judge Mahady said, them children need both sides. And I'll tell you, Honorable Committee, it never happened again. I had my kids every weekend. I mean, I just can't imagine what Mr. Haas must be going through, not to be allowed to see his children. Because I was lucky. I had a good judge that took the children first. We didn't have this GAL then. I think it's a very terrible organization, my personal belief. Judge Mahady then said, you know what, the children are first. And that is what should be here, and it's not. And I think Mr. Haas is definitely showing that the GAL and the courts are not taking the children first.
Mr. Chair, thank you. Is there not an RSA or part of the child, interest of the child, that if one parent alienates the children from the other parent, can't they be charged with abuse of the child?
But how do you
so there is an RSA.
There
right?
is, but how do you prove Section 11?
Well, a father calling, he has all the proof there. You have documentation saying you try to contact them over and over and over. And how long is it? Have you not seen your children now?
Since September 26, 2009.
And yet the parenting plan says both parents. You're supposed to see your child according to the parenting plan for how long?
Wednesday nights from 5 to 7, and every other Saturday from 9 to 6.
So what other proof is there? I mean, sorry. Thank you.
Thank you.
Continuing on with the denial of phone calls, and I do want to give you a few more examples, because I want you to, I claimed that the GAL wasn't doing her job because she wanted payment, so let me also provide some evidence of this. December 20th, 2010, 9:31 a.m. To my ex-spouse at the time, I would love to see and speak with our daughters on Christmas. They deserve and need to know that their father loves them, and at the same time I could give them their Christmas gifts that I have for them. How could we work something out? Thank you. Nick, this is really short notice. This was a day later. Nick, this is really short notice, and the girls and I already have plans for the holiday. I have let the girls know that you were asking for them. That's it. So I write, and the GAL sees this stuff. She's been okay. How about a phone call with them? If you want to tell me when and where to call them, or have them call me at a specific time, we could work something out. Nick, you are welcome to leave a message for them on the house phone. Now, if you go back in the case, and I'll provide the committee the supporting evidence to the contact with the GAL and what she was seeing going on, so that you guys can see clearly what was happening. You'll see that I've been asking for telephone, physical, written, a contact with them on holidays, only to have her suggest that it was me not spending time with them and basically perjuring the court. The GAL, I was asking the GAL why she wasn't contacting witnesses. Wednesday, 5/6/2009. Nick, why have you not paid me? As I indicated many months ago, I will be filing a motion with the court about payment. Please tell your mother that I have not been contacting witnesses yet because you have not paid me. That's also, guardian ad litem can't do that. They can't withhold services because of payment. So I just want that on. But if you look up school forms, that's how I was listed on my children's school forms. You see the big X's? I was crossed out altogether. The schools didn't really know of me, and what they knew of me, it seemed like they were a little bit afraid. I started going to visit with the schools, and I was finding out some very concerning information. One of my daughters had written in one of her journals in the classroom, "All I want for Christmas is for my father to not lie." She was in kindergarten. And the only way for a small child to believe that about one of their parents, respectfully, is when they're coached. You can read so much information about what parental alienation is. And, you know, right now they're trying to get it. They're trying to get parental programming and parental alienation accepted into the mental health, the APA. They're trying to get it diagnosed as an actual disorder, and they're very close to it. Some countries altogether have made it a serious crime to alienate children from their parent. We haven't in this country, but in other countries they have. If you look at Australia, they have, and some others. It's a crime. I expected that the GAL was going to do her job. I expected with the bill she racked up of $9,000 that she was going to do her job. I put my faith in her, in her abilities to do her job, and she withheld all this stuff from the court. At the time, I was telling the GAL, even back, this is December 30th, 2008, when, you know, clearly when she was still new. I explained to her that the girls had been apologizing to me for talking bad about me. My daughters actually, during the visitations, were telling me that they were sorry because they were talking bad about me. I told her that my daughters were expressing they were confused about certain things that I was purchasing, that I bought while we had our time together. There were some watches that I purchased for them. They were little Disney watches. One of my daughters kept this in her special place. It was a little easy bake oven that she could keep the watch in because she said that was her special hiding place to keep things. And they admitted that at the time, Mommy wouldn't let them wear these items out.
Chairman?
Yes, question, Chair.
Yeah, I do have a question. We're at a point here, you're just coming in, we're at a point here that if we were in court, the court would be saying the testimony we're getting is cumulative now. You know, we've had plenty of testimony to show that the guardian ad litem didn't do her job, the courts weren't enforcing the parenting plan, and what we're at now is getting incident after incident after incident that basically just says the same thing. And I wonder if it's possible to wrap it up.
I actually had that feeling having just sat here for 2 minutes when we've been here and done this. And we would appreciate if we could close it out and make any next points, get right on with any other points, and keep us strictly in the closing phase.
Sure thing. I can close this up very quickly.
Yes.
What I brought before I tried to summarize for your honorable committee in my redress of grievance the 5-6 page summary, okay, which outlines details of what happened. What's really the critically important document in this is really the points of law and the parties involved document. Every single one of these have been broken. These statutes have been broken in my case. And if the committee wishes for me to expand on any of those, I can. But if you'd like me to wrap it up and simply say, okay, we've got enough here, I completely understand and can respect that. It's a crime to interfere with visitation in custody. 461 is very clear. And the statute's very clear as it relates to the guardian ad litem's responsibilities. So using that, along with a plethora of other statutes that were ignored in my case, and you can go to the court and get the files. You can research this. You know, they're all right here.
What level of documentation have you given?
Yes, I've been.
You've got all that. Just want to make sure that tells us something. new, like you have to go digging.
I-
It would be useful.
If you did have to dig, I would certainly be there and would be more than glad to point you
Bring the
to
shovel? Yeah, that'd be great.
to a specific, this is only a summary, unfortunately.
Representative Higgins, for a question of the,
Thank you, Mr. Chair. At any time during this period, did you want to go to the guiding ad litem board or have a presentation to the judge about the behavior of the guardian ad litem?
Yes. I went to the Guardian ad litem board over a few years ago and presented this to them. They said at that time they could not get involved because the case was ongoing. I challenged and said they absolutely could because it states in their bylaws that they can get involved in a case like this for good cause. And I specifically outlined 10 specific points to the RSAs that she was breaking, saying that this is a good cause for you guys to get involved. They chose not to.
For the follow-up?
follow-up.
So subsequent to that, have you been back? You said that was several years ago.
Oh,
Have you filed
yes.
again?
March 16th, this past March 16th, 2012, I was before them and I presented the, in my redress, you'll see the violation, the standards of the best interest of the children. I presented this case to them. But for the record, they had heard much of this. And they didn't take action in the matter. I've written, just on that point, Representative Keynes, I've written to everyone. I wrote to Gene Shaheen. I wrote to Jeb Gregg. I wrote to Attorney Delaney. I wrote to Judge Edwin Kelly. I have written letters to everyone, and I've been trying to see where it is I could go, because after making multiple motions, which you will see on the file at Manchester Family, being denied consistently, as Representative Sword, alluded to earlier when he was asking, to no avail. So I'm here before you because, going back to my school days, I realized that I've got 3 branches of government: judicial, legislative, and executive. And currently, in my case, in my proceedings, we do have the executive level of government. I am currently working with an agent, the Federal Bureau of Investigations. They're looking into potential color of law violations in this case.
Further questions of Representative?
Yeah.
I guess in your summary, you referred to GAL wrote what you thought were incorrect reports, and you feel she was conspiring for the ex-wife. So is there malfeasance? Is it simply that she wrote information on the reports that you believe that untrue, which she thinks is untrue, or is there other things that the GAL either should have done that she didn't do, or did that she shouldn't have done?
Representative Horgan, that's a great question. If you look at the evidence that I have of the ongoing dialogue between myself and the GAL, it's in utter contrary to what she was placing on her reports. Furthermore, my challenge is this. My parenting assessment and psychological evaluation deemed me a fit parent, which she asked me to do. I did so. I'm challenging why her 2 reports are on the record at all. Because, for one, she was never asked by the court to provide the reports, which you will see, because she even says in one of the 2 reports, I haven't been asked to do this, but I'm putting this on the record. If you go back to our emails and you look at our correspondence, it's pretty clear that it was starting to heighten between the 2 of us as to her not doing her job, and I felt she wrote those reports at the time clearly to distract the court. There's only been 2 reports she's had. So they're not only contrary, they're completely contrary to this, and also not contacting witnesses coming forward that we're trying to contact, all this stuff. I mean, how can it be credible what she's written when she's neglected to do her job?
Further questions, Mr. Smith? We need to get to remedies. Have you discussed that at all? Has anybody discussed it when I'm not here? We need to get rights to remedies, and we'll talk about those between you and Representative Burton. Legislative remedies. I was reminded again that that's what we do here, is legislative remedies. Where's that petition? I'll read the first one, and why don't we discuss it if we can get beyond that? Would that be fair enough? Number
Yes.
one is determine if there was maladministration on the part of Judge Edward D. Tenney, Marital Master Green, and Marital Master Jennifer Lemurs, and consider commencing articles of impeachment against such judge and marital masters. So you're asking the House to do a basic research into impeachment.
Correct.
Two, you want to say more about that? I think we're all clear on what that means. Two is review the views and statutes in the grievance and determine what authority the legislature has, it says, in case for corrective action. You're probably outside of our power, you know that, but I think we all understand the questions. Anybody have questions about that, or do you want to clarify what you're asking for?
Oh, yes, I do.
Or maybe even alter it.
What I mean by that is Article 31 says that the legislature shall assemble for the redress of public grievances and for making such laws that the public good may require. Article 32 also says that people have a right in an orderly and peaceable manner to assemble and consult upon the common good, give instruction to their representatives, and to request of the legislative body by petition or remonstrate redress of the wrongs done to them. When you look at the definition of redress, it's a relief from a distress. This is my distressful situation. I'm asking that your honorable committee take action in the matter, relieving myself and my children from the distressful situation. It also is, redress means a means of obtaining a remedy, which is also compensation for a wrong or loss. I'm not before you today to say I have an amount that I think should be compensated. I'm not before you today to ask for specific, award of amounts. I'm asking you to look at the statutes, determine if these have been broken in my particular case, and then with what I've had to put in into these matters, and for what's going on, we have a hearing, or we have a meeting on what that compensation, what that should be after all of this is done.
Thank you for that. I appreciate the definition, the reminder of the definition of redress. Any questions on that point? Representative Keyes?
Only that I think you and I have just come from a meeting where part of what he just asked for, we were told would not be forthcoming. There probably won't be monetary reimbursements, and there won't be probably censure of judges or impeachment. That we will look at individual statutes and see if there need to be corrections in those that provide for more due process. Okay.
It doesn't limit
I
this
just want to
committee
make
from
sure I didn't
recommending.
misunderstand the meeting. We just
No,
immediately
it doesn't limit this committee from recommending whatever the heck we want, though. Actually, it's the power of the committee to do that. So I understand what you heard from the speaker's office and what the speaker said to us. I do understand that. And I, frankly, as much as I defer to other members of the House and the speaker and all, I defer to the Constitution first, and I'm not going to take a position. I didn't necessarily agree. I just simply nodded my head in awareness of what he's saying. So I'm not going to put myself in that position. I'm not going to go to member Shell and Representative
Thank you, Mr. Chairman. I have a question of Mr. Haas. There is a cause of action against attorneys for ineffective assistance, and I wonder if you or your counsel looked into the possibility of there being a cause of action against a guardian ad litem under a theory that you're a third-party beneficiary of supposedly of what they do, and if they haven't done their job, whether there's a cause of civil action against them.
Representative Sword, I went to the Judicial Conduct Committee. I asked them.
That's almost enough said right there.
I asked them, sir, to do something in the matters. They said that Miss Decker was operating outside of her profession of being an attorney in these matters because a GAL is quote-unquote parties to the proceedings, and they weren't representing me or my ex-spouse as an attorney at the time. She was simply there for the benefit of the kids. I said, but if the end result was that we were affected in a severe way, and that we were harmed by her actions, she is an attorney and should have known, based on the ethics attorneys have to subscribe to, she should have known that she was outside of her capacities as an attorney as well as a GAL. And my case in point was when she instructed my ex-spouse to withhold telephone contact from my children, she must have known that she was overstepping the authority given to her. The JCC ignored, well, I'm sorry, I won't use ignored, Representative Willett. They denied my requests. I have returned letters from them saying that they're not going to get involved. And they asked me to go through, they actually asked me to go back through the course.
Other questions on remedy? Do you have a follow-up?
Yes, well, that may not be a bad thing. I'm not surprised at all, just editorially speaking, that you're not going to get any help from the judicial branch about people operating the judicial branch. That's a good part of what we do here is trying to deal with that fact of life. But I also know that there are attorneys who specialize in suing other attorneys for failing to do their jobs. Yes, and I'll just throw that out to you, that's a possible avenue of redress more effective than anything we might be able to do here in the legislature.
I've been trying to look into that. I've been trying to look at where to go. I had also gone to the Supreme Court in these matters. They're a part of this petition. I had 4 motions filed with them. Every single one was denied by a single justice, Justice Lynn, and stamped them back and say it's denied. I wrote a writ of mandamus and a petition for original jurisdiction, and boy did we do a lot of work at home on those for weeks, only to show up making 8 copies of them for every justice to walk out and an hour later just have something scribbled that said denied. That's not justice. That's not hearing the public. That's not servicing the public. My opinion.
Thank you. Oh, I'm sorry.
I thought.
Do you have a follow-up?
No, I'm fine. Thank you, Mr. Chairman.
Thank you, Mr. Chair.
Regarding petition 2?
Yeah, petition 33. How much have you, a rough ball figure between GAL and what it's cost you before you started to represent yourself? What are you looking at? What it cost you?
In attorney's fees in the GAL, just on attorneys in the GAL, slightly less than $50,000.
Okay, now do you think you have another $50,000 to go and get another representative to further your case?
No, in our household, no, we don't, no.
Thank you.
I can't afford it. Couldn't afford 500. And most of them, and let me expand for a moment, most of them told me the same thing. They said, your case is going back to the court to tell the court it made a mistake. Do you know how expensive this is going to be? And they said, you've got to come up with a $5,000 retainer just to get the process started, but I'm going to be built. And most of them said, they either said, one, that's a feat, it's an impossibility, I'm not going to be able to represent you, and 2, it would be too costly, it would prohibit me from being able to represent you. Attorney David Braderman started it back from, and you saw this in the beginning of my petition. David Braderman, who is a wonderfully respected attorney, Braderman Law and Concord, explained to me flat out. He said, this is an impossible situation. We filed a motion for reconsideration. If the judge was going to deny that and wasn't going to listen to that from the start, for me to go back in there and file multiple, it's just going to cost you more and more and more money to the point where you'll run out of money. And I'm not going to do that. You're in a sinking ship. I'm not going to be a part of the ship. And that's exactly his words. And most attorneys I went to had the same thing to suggest. That and, when you're fighting against deep pockets with an attorney that's a criminal defense attorney, you have a rough chance of winning. Every time I do go to court, it's
Did those attorneys suggest to you that you don't have a good cause?
No, I have never heard that.
Now, third point, broaden the investigations to further determine if there are similar failures that possibly suggest a pattern of problems that should be corrected by legislation for New Hampshire families. That is what we do here, as you know. We are doing that. We're collating information and finding out if there's a pattern. And we're also just, with our ears, finding patterns already. So I understand that's happening, and that is probably what we're doing best, what we're going to be best at doing in the future. It does then lead to legislation. The question still remains, if which puts it about whether or not we go back to another time when we used to actually take care of people when they were biased for that. So that's all I can say.
Thank you, Mr. Chair, but this is, we've never really sat down and had a work session. Okay, so that is something we haven't really even looked at, and we have a couple good ideas of what we'd be able to do, so.
I am forming a committee. I've already, on my piece of paper, named the members I'd like on the committee to just look at family courts. And you have 9 cases in front of us. So that's a personal look, a closer look, and the other part is the collect data. We came up here actually because we believe in good government, and part of it is eliminating something, and part of it is adding something. That's persistent. So.
For the record before the committee, I do believe that New Hampshire does have some wonderful laws, and I believe that if they were enforced, you might not see as many petitions. I do believe that my case in this petition, the reason I'm coming forward is to also try and help. If we can correct things for others so that they don't have to go through a process such as this, then that would be wonderful. We'll not only save other children from going through these kinds of situations, which is ultimately my goal, but it will also save taxpayer money. It will save the court's time. It will save the legislative body time. And efficiency in government is always a good thing.
Would you go back? I agree. I appreciate that point. I think we've heard that from virtually everybody who comes in. Would you just go back?
I didn't ask him.
I just want to go back to a question, because you said, I made a note, and I didn't actually hear what you said about it. You said you contacted both the Attorney General's office and the Office of the Administrative Judge, Edward Kelly. And did you say you didn't get a response, or you have responses for it that we can look at?
No, just one moment, Chair, please. I will. I'm going to read this one. Yes, I'm going to read two letters. April 2nd, 2010.
I'm not sure we need you to read it.
Oh, okay.
Would the committee prefer to have it, or would you like us to read it?
Could you just do this?
Will you give a synopsis, just of what they essentially say?
On April 2nd, 2010, in this letter, I wrote to Attorney Delaney. I explained I was a 36-year-old father of 3 wonderful children, the stepfather of 1 great little boy, and that I lived in Hooksett. And I was writing because my children and I had been victims of parental alienation. I needed help because the court, so
we know the context.
Yeah.
So tell us. You asked him, what was your question to him specifically then? What did you say?
Will you meet with me so that I may explain the situation, provide you evidence, and see how you might be able to help? And then I wrote April 21st because in this letter I was told by, so on the 20th I must have been told by a member of the staff, one of Attorney Delaney's staff, that I would receive a return call about the letter I sent. I received no call. And then I was told over the phone that the office had sent a letter to me in the mail, and it was saying they couldn't be involved in my matters. June 6, 2011, this is an example of one of many, many, many examples where I wrote to Judge Edwin Kelly, Administrator of the Courts. And I just told him I had, please consider a meeting. I'm begging you to allow me to present facts to you. And I explained to him this is not a case of me being sour grapes from some bad decision, that this is about statutes and things that he should take a look at.
Did you respond?
And I received it from him that he could not be involved in the matters. But these are just some examples. I mean, if you want a list of, I have multiple letters I wrote to many.
No, if you include them, that wouldn't be bad for us.
Yeah.
It's
And
important what his response is a key part of our discussion. If it's an administrative question, it's a big deal.
sure.
It's just bad administration.
Many, just for the record, many people did write back. I mean, I heard back from a lot of senators, a lot of Frank Enta had written back to me and had provided a lot of attorneys that I could contact. That was nice of him, but there was attorneys that some of them were already on the list. I
think I have Representative Hargan for a question. After Hargan. Representative Hargan, okay.
Did your ex-wife attorneys ever offer you a settlement? And I'm assuming, and if they did, I guess, just explain a little bit why it wasn't acceptable.
That's a wonderful question, Representative Horgan. I never received any type of settlement. Mediation, I thought would help. It did not. They went into a room on their own, and I never even knew what happened at mediation. Next thing you know, it was just all shut off the record. I wanted to. I wanted to for the benefit of my children. They never offered. However, and I do want this on the record, the GAL told me in court a few times that this could all go away if I just would go to settle with them, which I thought was probably very interesting to say.
But like her own attorneys, or she and her attorneys never contacted you in a settlement.
That's correct.
Representative Hardwick.
Thank you, Mr. Chair. In the response that you received from the Attorney General's office in the court, what you stated was that they couldn't be involved. Did they give you any legal reasons, statute or anything, as to why they would not get involved?
Being Attorney Delaney's and Edwin Kelly's office, I could produce the letters. I don't. The GAL board. The only ones, okay, the only ones, no, they did not. I know that's sorry. No, they did not. And I don't mind. I could provide the committee a copy of those letters, if that would be good. If you would like that, I would be more than glad to show you the letters I sent and then the responses that were sent back, so you could read.
Thank you, Mr. Chair. But do you have an open case? Are you still an ongoing case here? Thank you.
Never end. Thank you. Representative Burt, are you have a final statement?
Yeah, I do. I don't know if you want me to do it in the subcommittee that you have, or the committee, or I just got a couple suggestions that would really help, for future legislation.
Well, that's what we're listening to right now. Why don't we do that in something?
Okay. All right. I'll keep it.
Yeah, and would you guess that such suggestions apply to multiple other bills? Other petitions, would you guess, based on what?
Yeah, absolutely. I think it would help the majority of them.
Be much appreciated, yeah.
Point of order. Could I address Representative Keynes on something? it is an ongoing case, but many of the motions are motions that I have filed. And the parenting plan isn't being enforced whatsoever. And it is the standing orders of the court. So you're in an impossibility. If they can't get involved because the case is ongoing, the record will show you, I've been filing motions to keep, to fix this, to no avail.
Conservation, by their nature, these cases never end until the children turn 18. They're always over. So you're in that catch-22.
Are you saying they don't close because they can't really be closed until 18?
Well,
or they just simply don't, nobody wants to
As a practical matter, Mr. Chairman, until the children turn 18, the case is always subject to modification by the court. So they don't. So he's in a catch-22 where if they're using it as an excuse, the case is ongoing, then he's never going to get any redress from the judicial branch.
And Representative Sorg, that's exactly why I'm here before you, because I have lost my faith in the judiciary to fix this. So now I have gone to the legislative arm of our government and also the executive arm, because when one arm isn't going to help you and isn't going to help your children, we've got to find a different branch, because I think I've exhausted the judicial branch, unless I'm missing something. I appealed to the Supreme Court 4 times.
The status of your FBI discussion is that?
They're just kind of monitoring. I'm in an assessment stage. To launch an investigation is quite costly to the federal government. So what they do is they just kind of keep an eye. They're looking through what happened. They look through kind of the case of what happened with the incarceration. And to prove a color of law violation, it's extensive to prove a color of law violation. Are they going to do something? I don't know. I hope so.
This committee, have you been heard?
Yes. Thank you for your time.
Thank you very much. And this session is closed. We'll be back at 1 o'clock.
I got a question. Mrs. Keynes about the AG's office. Well, was there something that concerns us? We the people?
Well, we had a general discussion about whether or not the legislature, what the powers are of the legislature to affect individual cases and that sort of thing. All of us do agree that we are a judicial branch. We don't necessarily all agree that there isn't something we can do, however. So that was the nature of that discussion.
So you will not be able to subpoena?
No, it was not with the AG. No, it was not with the AG.
Okay.
So no. No, the AG is reacting to us, and that's what the press conference is shortly. This committee needs to know that I did call a press conference. It's on behalf of
Noon downstairs.
I mean, I'm doing it as a reaction because of the charges. I'm named in there, the committee's named in there, being problematical. So I'm just trying to correct some stuff and welcome to do that.
How many children must go through with this before it's a crime? I mean, it's continuing this day. There's people that are getting divorced at this day, and they're probably going through the same thing. I mean, how many children must be hurt? How many thousands have been hurt already? How many hundreds of thousands? It's a crime.
To speak strictly for myself, but it may reflect the thinking of others. To me, it seems like the legislative branch has been in awe of the judicial branch for so long, just out of habit. We conclude that nothing they do is subject to any kind of remonstrance from us, because that would not be proper. And we've got to kick that habit, that mindset, before anything's going to be done, that they are subject to oversight, and
It would be nice.
Representative?
it's going to take, I guess, the equivalent of a 2x4 between the eyes to get the legislature to do something.
Well, here's, if I may, if I could comment on this. If they're not following the statutes that you work so hard to protect people with, then what confidence do we have in the judiciary? And furthermore, in their own canons, and the Supreme Court says this in their own canons, it says that the public's confidence in the judiciary is paramount. It has, when it's questioned, there's a huge problem for those judges and folks that are being questioned publicly. It's in their own canons under Supreme Court Rule 35. Unfortunately, I have to learn this.
Judges judging judges.
Right. We need, yeah, 461 is very clear, and in my case, that's why I bring the GAL. Thank you.